but it's one document, not the LLC and the corporation, et cetera, et cetera. And it will state the ownership process. This is for wealthy people because the reality is we have to pay property taxes every year. Where's that money going to come from? Because who's the true owner? Why should I pay the property taxes if it's in this trust and I really don't own it? And so it becomes an interesting dilemma that way. So you want to always make sure there has to be the money to support the property. So we don't, I mean, as much as we want, we're going to never sell our house, we're going to live in it forever. You've all heard it. But there's a reality to that. That your kids may not want to live here forever. They may not be able to afford to live here forever. Health things come up. Life changes. So we try to limit people in that type of thinking. But we can set it up toward that type of thinking. But we always want an out should we not be able to afford. Because we live in a very strange place that not a lot of people can afford to stay in long term. So, but yes, that's one version. But yes, we do that type of thinking. But there's also easier ways to do it.
I'll be talking to you, and I love what you said, and I know it's doable. And by the way, I'm also a tax specialist.
Okay.
So,
Yeah.
but it's important how to do it. I know the process, but
Correct. And like I
it's
said,
too much work.
it is. And I said, then you have to file tax returns every year, etc. And I said, these things are owed. And who's in charge and who's going to pay it and how they get along. There's so many different dynamics to it that isn't really worth it for a house. You're all realtors. You know, it's a thing. Sell it, enjoy the money. Enjoy your life. Let it serve you while it serves you, but there comes a point at which it doesn't serve you. It is a thing. And this thing needs to go so you can live a better life. Sell your $1 million and live somewhere where you can live in a really nice house, relax. So we have those conversations all the way around. Like I said, for some families it works for, but I said for many it doesn't. But I just want you to know that's the kind of approach you're going to get from me is we have to really think out, why are we making it this complicated? Why are we doing this? And if it is just a control thing in you, we got to talk about that.
So the other question is regarding the best witness is the eyewitness. But if there's no eyewitness, in other words, so the signatures and whatnot, can it be recorded and visible and admissible in court?
Oh, there's some evidence code sections that would allow you to do that, but the witness has to be unavailable, typically. That's another benefit in arbitration is that there's a lot of flexibility. You can submit evidence by way of declaration, although it's not given the same weight as a live witness. You can have a witness testify by video. You can present deposition testimony. And you know, if there's issues on handwriting or signatures, you can introduce an expert's testimony.
All right, thank you.
The next question's over
I have interesting things, so I just wanted to get your input in it. It's a true case. A client, a buyer, get into a contract with a new builder. Last year, towards the end of the year, they lost a lot of money in the stock market, so they couldn't close. They offered to pay a little bit less than what they were originally in contract with. The lender says no, and then the builder says no, and they turn around to sell this property to another buyer with 100K less. And then they confiscate the buyer's deposit, which is a lot of money, is over $2 million the house. So now the buyer wants their money back. The builder says no, so they're gonna go to arbitration. So I have two questions. One is, does the builder have the owe the buyer a good faith to work with them? If they're gonna sell it for $100,000 less, will they sell it $100 less to the original buyer?
Good faith doesn't exist in that kind of situation. I hate to say it. I mean, you know, we could talk offline about this, but the things I heard were the buyer couldn't honor the contract that was signed, and that the seller, it was a builder, sold the house for $100,000 less. So those aren't good facts for the buyer, the initial buyer. And there could be reasons, but unfortunately, a person's financial wherewithal decreasing isn't something a judge would consider.
Can I just make a suggestion, because we want to get to everyone's questions, and I'm having to go back and forth. I need you to stand up if you want to ask a question, so I can get the mic to you, okay?
Sorry, we only have 2 mics, so we have to work with what we got.
So I recently had an issue with a buyer-parent transfer. Okay, so my question is very simple. Parent-to-child transfer, who's responsible to make sure that the taxes don't get reassessed?
The trustee, who is this agent? Or who's the person doing this?
Parent sold to child. Interfamily transfer.
It's the child. If you don't want your taxes reassessed, make sure you work out that paperwork.
So they did the paperwork and title, the standard paperwork. Is there a follow-up piece they're required to do? Because they got reassessed and I had to overturn it all.
No, the county, again, undertrained and overworked. And there's a reality that they just don't know what they're looking at. Or as we know, our clients skip a line, they don't fill it out exactly right. The county cannot fill it out for you. They are a machine. They work in a way that they cannot specialize to everyone, because if they did, they would never get anything done. So the reality is, in that situation, I feel it's on the child. If you want your property taxes reassessed, make an appointment with the assessor and go down there and fill out the form again. And make that interface happen. Because you can actually make an appointment with the assessor and sit with them and fill out the forms. So it's that situation.
It's not a title responsibility to make sure that they've completed the form and it's filed.
Correct. No. Because again, so you guys know, title is just that. Are we selling it to the right person? Is the right person signing the paperwork to the right person? Is it following a chain? Once that chain is completed, the county assessor is its own entity. You need to work it out. Because again, if they did it for everyone, title would never get anything done. So we all have to take personal responsibility, and it's typically always on the buyer. Because once you sell, you walk away. And so it's always on the buyer to make sure that those paperworks go through. But you can contact the county directly, and we can supply you that information to make those appointments.
Hi, Lisa, this question is for you. In a normal, standard estate planning, family, 2 kids, a house, huge equity, $3 million plus, and maybe a rental. What are the 4, could you describe the 4 most important documents in the living trust or estate planning? And a question for Lino. Lino, can you give us an example of where you experienced a litigation where the agent and the brokerage lost, or do we always win?
A living trust, again, is the main box, the main document. A living trust should be about 30 to 50 pages long. If you have a 7-page trust, which is very common, it is no good anymore. You must have that reviewed. So it's the trust. Then you have what's called a pour-over will. This simply, 1, declares who your family is, so we don't get anybody come out of the woodwork saying I'm your long-lost child. But second, should you forget to put anything in the name of your trust, as we talked about before, with court, I rely on this pour-over will. It says everything you own, you pour over into your trust. So you got to have a pour-over will. Then, of course, the financial power of attorney. It is its own document, separate. It's separate from the trust. It's its own thing. A power of attorney nowadays is about 25 pages long. The standard one that we've all seen on the internet, the Uniform Code 1, and it has all these lines, and then you just check 1 at the bottom. It says everything above I intend to do. No longer stands in court. It will not, especially nowadays with digital assets, needing to get passwords online, changing beneficiaries. It's not good enough, and that's typically a 3-page form. It may serve if you're truly on your deathbed, but in reality, it's not going to stand up to what you really need. So the financial power of attorney. And then your health care directive. Do you want to be on life support? Do you want to be an organ donor? Do you want to be cremated or buried? This is the person who actually makes the arrangements with the funeral home. So without it, you have to have all your children together, and then the majority of them have to agree and sign off at the funeral home. Your kids are stationed overseas, they live out of state. It's a pain to get all your kids together, but you got to with the funeral home if you don't have a health care directive. So So the trust, power of attorney, the healthcare directive, and a pour-over will, those are the 4 main ones in an estate plan. An estate plan should be about yay big nowadays in a binder.
Thank you. Lino?
So the short answer is agents are always in the food chain. Let's put it that way. Okay, when a litigation starts, and that's when the initial demand for mediation starts. Typically, it's the buyer, seller, and both agents. Okay, then you go to mediation, and quite often a decision's made, a business decision's made on the agency's part to make some kind of contribution to the settlement. There's one case in the last couple of years where I found there was an agency liability where I represented the buyer, but they had been with this family for decades and decades and were really part and parcel with the seller, knew all of the things that had been done that weren't disclosed, and it was a pretty egregious case. But agents tend to get in the food chain from the beginning, and then as the process goes on, through arbitration, most of the time they drop off. Okay, but they do contribute to settlement on occasion.
Thank you.
Quick question for Lisa. If you have assets in a foreign country, for example, England, can they be covered by the living trust in this country, or do you have to do a separate living trust in that country? Do you know?
You have to do a separate living trust in your country. We can include a statement of intent that you intended to go to so-and-so, but it actually has no holding but for you to take it to your country and try to enforce it over there. However, for Medi-Cal, foreign assets count against what you're allowed to keep in assets. So you always want to disclose foreign assets when you're applying for any government benefit.
You mentioned something about cremation. If the father wants to be cremated, but if the children do not want that, what happens?
If we have it in writing, it overrides. But you always need to make sure you name an agent who's willing to carry out your wishes. So if it's not your kids, that's okay. There's what we call private fiduciaries. These are people licensed and bonded by the state of California to be your agent for you. I had a situation, I had a young gentleman, he had cancer his whole life and received cancer treatments. He wanted to donate his body to science so they could study his cancer treatments. His family was very, very Catholic and very, very against it. But he signed a healthcare directive and he directed it that way. And there it went. UCLA came and picked him up because it was his wish against his family. So it does happen, but you want to make sure it's in writing because it is your body ultimately and you have the right to choose.
I had 2 things. First of all, it's a comment in regards to that. I hope as real estate agents you can see the value in having associations with obviously real estate agents when you first come aboard, right? And especially when you're talking to people that might have multiple properties, right? What about additional states if they have it in other states? Would that one living trust encompass all that?
Yes, but you have to deed out-of-state property into your living trust. Every state in America now has a probate court, but the limits on probate are very different. In California, it's anything over $150,000. You can imagine in Nebraska, it's probably anything over $30,000. So the point is, you don't want to be naive to think, oh, I just own this weird house in Texas and it's not worth much. No, it all adds up, and so you want to deed all out-of-state properties into your living trust, and then it can be administered from your one location wherever your trustee lives.
Can a healthcare directive be holographic?
It can be, but you're opening yourself up to litigation, to fight over it. Is this really Dad's handwriting? It needs to be notarized. If nothing else, your signature just needs to be notarized. That holds up quite a bit of weight in court to have another party, besides your other witnesses, signing for it. A healthcare directive can be gotten from any hospital. Kaiser's typically is just only good for Kaiser, so you may also want to pick one up at any other generic hospital as well. So you can get one from any hospital. You can typically now print them online, but you want to typically use a standard form because I said it's just less to fight over.
One brief question real quickly. without going into any kind of details, can a prior legal will challenge any kind of a living trust?
Living trust always trumps. Always. A will is simply directs it to the probate court. That's just it. Many of us know people who just have a will. Why bother nowadays? All that's going to do is direct it to a probate court, which is the same thing that would happen if you didn't have a will at all. So the trust always trumps.
So we, unfortunately, we want to respect the time, but both Lisa and Lino will stay behind and answer the questions up front. And remember, Lino have flyers up there in front of you. If you don't have a copy, let us know. And there's also brochures up here as well. So I want to really, from the bottom of my heart, thank you both so much. For letting us ask you all these questions and being here. I know it's you have busy schedule. So before we go, I want to say a couple things. I hope you all enjoy that. Yeah, and you should have received a survey form. Yes. Please fill it out for us. We want your feedback. If there's any topic that you're interested in learning more about, let us know. We're here to serve you. So let us know any feedback at all. And then we also have the next Brunch and Learn that we have is going to be on February 15th. So please mark your calendar. We'd love to have you at 9:30. Come here and network. Share different ideas. So we all want to support each other. We're a tight community. And our topic next month actually is going to be automation marketing. It's going to be presented by our very own Rob Bates, as well as Mark Messenger from MLS Listings. So you do not want to miss it. If it's automated, it means that you set it up, you walk away, and it does things for you. So what's better than that, right? So we want to see you here, and like you said, like look at today, we're full house. So if you're interested, please go on and register, and you can to register.